The Unlawful Activities Prevention Act is another important or the major law that today deals with terrorism in our country. The Unlawful Activities Prevention Act of 1967 in fact was the earlier one that dealt with unlawful activities of the group or an individual. It was used to charge the offenders who were involved in terror related activities. Until 2008 amendment was done to it, it had certain provisions which were again against the human right of the accused or were not enough to deal with the menace on the other hand. The earlier act consisted of provisions essential to prevent unlawful activities of the individuals and associations and for matters that were connected therewith. Committing any unlawful activity, which is in fact defined under the act as in relation to an individual or association, means any action taken by such individual or association, whether by committing an act or by words either spoken or written, or by signs or by visible representation or otherwise, was punishable under section 13 of the act, provided it had the following components, which is intended or supports any claim to bring about on any ground whatsoever the cession of a part of the territory of India or the cessation of the part of the territory of India from the Union, or which incites any individual or a group or the individuals to bring about such cession or cessation, which disclaims or questions or disreputes or disrupts or intended to affect the sovereignty and territorial integrity of the country, or which criminalizes membership of an unlawful association and also the acts of dealing with the funds of such unlawful associations. The amendment that was made to the act in the year 2008 widened the scope of the term terrorist act under section 15, 16A and 17, and also from sections 18 to 23 etc. were all togetherly, which actually resulted in widening the scope of this particular enactment. The current law with the amendment includes most of the direct as well as indirect acts of contributing to the crime of terror, including attempt, abetment, facilitating terrorism, funding terrorism and such other indirect ways of contributing to the menace. The act authorizes states' power to forfeit the proceeds of terrorism. The 2008 amendment also inserted new sections from section 43A to section 43F, which all togetherly empowers the investigating agencies with tremendous powers, including that of arresting and seizing the property or confiscating any incriminating substances. The act extends the custodial detention of an accused for a period that can extend up to 180 days and also provides for the denial of bail altogether to a foreigner who is accused of terrorist activities in the country. The act provides for presumption of guilt of the accused, thereby shifting the burden upon the accused, which is again contrary to our existing criminal justice system's basic principles that intends to safeguard the interest of the accused. Any person, whether an Indian or a foreigner, under the enactment who directly or indirectly raises or collects fund or provides fund for a terrorist act can be punishable under this enactment. Those who organize camps for training in terrorism and those who recruit persons for the purpose of committing terrorist activities can also be punished under the current law. The act makes almost all the offences cognizable, thereby empowering the police to immediately arrest the accused involved in these kind of crimes. The act provides for establishment of an agency called the authoritative agency under the enactment at the central level, which is empowered to prop terrorism and other crimes which are having national ramifications. The act provides for the establishment of special courts to conduct the trial of the offences that are dealt with under the enactment. In August 2009, the Indian government issued an order detailing the implementation of provision 51A of this enactment. Then we have the Prevention of Money Laundering Act, which again indirectly attempts at tackling the terrorism. Prevention of Money Laundering Act of 2002 came into force from 2005, July 1st. The act obligates banking companies, financial institutions and other intermediaries to verify the identity of the clients, to maintain records and to furnish information to an institution set up in order to receive these kind of information called the FIUIND, that is the Financial Intelligence Unit of India. The act aims to prevent money laundering and provides for confiscation of the proceeds that are derived from such money laundering or related activities. The act in fact has certain provisions which could be considered as those that tries to deal with funding for the terrorism or other ways of helping terrorist activities. In order to remove the procedural difficulties that existed under the earlier act, certain amendments were made to the enactment through the Prevention of Money Laundering Amendment Act of 2009, which received its assent in the year 2009 itself. This newly enacted or amended law incorporates certain provisions to combat financing of terrorism and introduces a new category of offences which have cross-border implications. It allows for attachment of any property, search of any person, but only after the completion of investigation. Certain financial institutions including the full-fledged money changers, the money transfer service providers such as Western Union and international payment gateways including Visa and MasterCards are all brought under the Act's reporting regime. Then comes the law that deals with a novel form of terrorism called cyber terrorism. It is a fact that today cyber technology, apart from being advantageous, has also become a tool in the hands of the perpetrators of crime. This is also true when it comes to terrorism. Today, most of the terrorist activities including planning, conspiring, abetting and many other such acts contributing to terrorism are taking place with the help of cyber technology. To deal with this, we now have the information technology of 2000 which underwent the changes in the year 2008. Now this 2008 amendment made to the Act has inserted a new provision, that is section 66F. Section 66F in fact gives a very wider definition to the term cyber terrorism, thereby bringing under its ambit any act of terrorism committed with the usage of cyber technology or information technology. The extent of punishment that can be imposed under the Act is life imprisonment. Thus, this section covers most of the serious forms of terrorism that are committed with the use of this novel technology. On the other hand, we also have some of the states having their own laws which has the application to the entire state. These are in addition to the national laws. So states such as Maharashtra, Karnataka and many other such states have their own state-made laws that also attempts at combating terrorism of all forms. For example, the Karnataka Control of Organized Crimes Act of 2000 deals with organized crimes that are committed within the state including terrorism. In fact, the Act aims at preventing, controlling and coping up with the criminal activities that are committed by any organized groups including terrorist groups or the gangs. Similar to this, we also have the Maharashtra Control of Organized Crime Act of 1999. Now this act also deals with the terrorist activities that are committed within the state. So is also the case of Jammu and Kashmir. The Jammu and Kashmir Public Safety Act of 1978, which is the progenitor of the NSA enactment, allowed detention of a person acting against security of the state and maintenance of law and order. The Act defines terrorism very widely and says that terrorism can be of 4 categories. That is, firstly, any act which causes or creates or could create or is attempted at creating feelings of enmity, disharmony or hatred on the grounds of religion, caste, race or community. That is, anything that is socially divisive. Secondly, anything to do with the use of force that disrupts public order. Thirdly, anything to do with the commission of mischief that threatens public order. And lastly, committing any act that is punishable with death or with the imprisonment that can extend for more than 7 years, that is any serious offence, that which threatens public order. So, you could see that most of the cognizable offences were all considered as offences that could come under this enactment, provided they were with the potential to threaten the public order. Now, in the northeastern region of the country, special laws such as the Armed Forces Special Powers Act of 1958 was passed. Now, and this along with the Disturbed Areas Act have been implemented in these regions to tackle the problems of not just terrorism but also of insurgency. The Act empowers state to arrest, search and confine any person on the ground of suspicion. The Act extended to the troubled northeastern states of Assam and Manipur, and it empowered police to shoot and kill any person acting in contravention of the provisions of these enactment. It allowed the detention of suspects for months without being produced before the magistrate. Even though these provisions are apparently against the constitutional guarantees of fundamental rights and other human rights, yet the justification for these acts application had always been Article 355 of the Indian Constitution, which entrusts Union government with the responsibility or the duty to protect states from internal disturbance. These in fact were some of the laws and are some of the laws that were and that continues to an extent to be applicable today so as to deal with terrorism. In fact, the analysis of all these laws today indicates the fact that most of the provisions of the currently applicable laws are in fact an extension of the earlier legal regime that existed under colonial rule, which empowered the state and its agencies with wider powers that often went against fundamental and human rights of the innocent people and also of the accused. Keeping that critique or criticism apart, the law today empowers our state agencies with ample powers and wider powers to tackle the menace of terrorism in all its forms, including narco-terrorism, cyber-terrorism, etc. Today's law just does not address the direct activities that are committed in the name of terrorism, but also covers under its ambit indirect contributions that are made to the acts of terrorism, including funding for these kind of agencies involved or the groups that are involved in terror related activities. Hence, what we today have are the provisions from the regular criminal substantive law, that is IPC, as well as the provisions of many national level special enactments as well as state level enactments. All these togetherly today forms to be the law framework that addresses the menace of terrorism in our country. Thank you.